There is no, it's like speaking Spanish to an English speaking person.
And proper personas or jurors or heritage of the land.
Ma'am, I said state your name. I didn't.
I will state for this X-rail.
Ma'am, listen, let me say this to you.
This trade name.
If I didn't think someone had jurisdiction over me, I promise you, I would not even get out of my bed. I don't really care what.
Welcome back, courtroom watchers. Buckle in, because today's hearing is the perfect storm of internet-fed delusion colliding head-on with real-world law. Our main player? A self-proclaimed sovereign citizen who believes a few magic words will somehow erase the court's authority. And presiding over this chaos is Judge Bryant, calm, sharp, and more than ready to dismantle every pseudo-legal argument thrown her way. We're talking pure, unscripted drama, bold claims of heritage of a land, repeated refusals to give a legal name, and a judge who refuses to let nonsense hijack her docket. You'll watch this defendant swing from defiance to near silence as the gavel of reality comes down. Pay close attention to Judge Bryant's strategy. She doesn't shout, she doesn't grandstand. She simply wields logic like a scalpel. By the end, our would-be rebel is practically whispering, "Think you've seen judges lose control? Not today." This is a masterclass in courtroom authority, and you won't want to miss a second. Let's dive in.
That's not case number. This is case number 174612601, the people of the state of Michigan versus Bonita Ayana Sealy. The defendant is charged with one count of assault or assault and battery, and today is the date set for an arraignment on a bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 8350505.
All right, ma'am, please unmute yourself. State your name for the record, please.
Islam, I self-law and master, and proper personas or jurors or heritage of the land.
Ma'am, I said state your name. I didn't.
I will state for this X-rail.
Ma'am, listen, let me say this to you.
This trade name. No, this trade name.
If you did not come to court, if you didn't come to court to participate in court, please don't come back to my courtroom. So I've muted you, so therefore we can't even hear what you're saying. So let me be clear. If you have not come to court, because let me just be clear. Okay, well, you have a great day. Have a great day. If I didn't think someone had jurisdiction over me, I promise you, I would not even get out of my bed. I promise you. Let me say this. If a person did not have jurisdiction over me, if I believed that a person, that an entity did not have jurisdiction over me, I promise you, I would not get up out of my bed. I would not take a time off of work. I would not stop anything that I was doing for that day.
Here's where the tension starts to build. Judge Bryant calls the case, calmly stating the charge of assault and battery. Notice how she immediately asks for the defendant's name, a routine step that becomes anything but routine. Sovereign citizens often dodge this question because acknowledging the court's record feels like surrender. But legally, it's simple. Without a name, the court can't proceed, and that's precisely why the judge insists. Watch how she keeps her tone professional, almost daring the defendant to escalate. This is the first chess move in a game the judge clearly intends to win.
To come to court to say these things. Number one, you know it's going to get you nowhere. There is no, it's like speaking Spanish to an English speaking. If you believe, Miss Sealy, from the bottom of your heart, that I nor this court has any jurisdiction over you, ma'am, don't come. You don't come. Because there's nothing, there is absolutely nothing. There is nothing that I can do for you. If you are not interested in proceeding in a manner that we can understand you, if you're going to simply read off some stuff to me, it's equivalent to me going over to England, since apparently you all don't believe that you're citizens. I don't really care what you believe. It is equivalent to me going over to England, getting arrested, and then telling
And there it is, the classic sovereign citizen word salad. Islam, I self-law, and master and proper personas, or jurist, or heritage of the land. These phrases sound grand, but have zero legal footing. They're recycled from online forums, promising secret legal loopholes. Judge Bryant's response is brilliant. She mutes the mic, calmly asserting control, and explains twice that if the defendant truly believed the court lacked jurisdiction, she wouldn't have shown up. It's a devastatingly logical point. Ask yourself, if you truly thought a system had no power over you, would you voluntarily log in to its Zoom hearing?
They don't have jurisdiction over me. If they let me go home, I promise you, if I didn't think they had jurisdiction over me, I'm not showing up. So okay, so we can try this one more time. If you want to state your name for the record so that we can have the name for the record, then you can state your name for the record. If you're going to say all of that other stuff to me that I don't have jurisdiction, then I'm gonna subside, and I'm gonna go ahead and move on to another case. I am going to remove you from the courtroom because this is going to get us nowhere. Nowhere. Now, by the time you've said all of this, by the time you've done all of this, this is a 2017 case. We probably would be finished with the case by now. Probably would be. Probably would be. Of course, I'm not going to give legal advice. I'm not going to say what she should do and how she should respond. Probably would be finished with this case by now. Okay, ma'am, please.
Watch the judge sharpen the lesson. It's like speaking Spanish to an English-speaking person. This analogy slices through the fog. She's reminding everyone that courtroom procedure is a language of its own. Refusing to speak, it only guarantees failure. It's also a subtle challenge to viewers. What good is self-proclaimed freedom if it leaves you unintelligible to the very people deciding your fate? This is Courtroom Reality 101, and Judge Bryant is the professor.
Davis Seeley.
Thank you, Ms. Seeley. Today is the date set for an arraignment on a bench warrant. How are we proceeding?
Innocent.
The court is going to enter a not guilty plea on behalf of Ms. Seeley. I will set this matter for a pretrial conference. This is a child abuse 4th degree case. Strike that. Again, I keep looking down at your client, looking up at your client's case. This is an assault or assault and battery case. The court is going to set the matter for a pretrial conference. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed. Probably could have already been dismissed. I don't know if you have contact with the complaining witness or not, Ms.
By now, the power dynamic has flipped. The defendant who once brimmed with pseudo-legal bravado is silent, while Judge Bryant lays out the simple path forward. State your name or be removed. No raised voice, no insults, just authority. Compare this to other viral clips where judges get flustered. Bryant's composure shows why experience matters. Her courtroom is not a stage for internet conspiracy. It's a place where the law is applied, period. Viewers, does this calm firmness impress you more than a shouting match would?
Ms. Ritter, however, the complaining witness is required to appear at the pretrial conference. Today is December the 6th. The court is going to set the matter for January the 6th. At 8:35. I'm sorry, 8:25. That denotes the arraignment portion. 8:25. As I indicated, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation for the failure to appear. Bond will continue with no contact with the complaining witness. Anything further?
Nothing from the people, Judge. Thank you.
Anything further, Ms. Seeley?
Emma,
Finally, the defendant relents, giving her actual name. That small act signals total collapse of the sovereign citizen facade. The rest of the hearing moves like clockwork. A not guilty plea entered, a pretrial date set, standard bond conditions applied. Notice how ordinary it all feels once the theatrics end. It's almost anticlimactic, proof that these dramatic standoffs often fizzle once reality takes hold. What started as a no jurisdiction battle ends like any routine arraignment.